Good morning. I'm Bonnie Gardner. I'm co-chair of the Public Affairs Forum of the First Unitarian Universalist Church of Austin. Our forums are most Sundays at noon at 4700 Grover Avenue. We encourage you to attend. They're free and open to the public. For more information about our programming, please go to our church website at www.austinuu.org. And now one of our forum committee members, Gary Bennett, will introduce today's speaker, Sheila Gladstone. Thank you, Gary.
Thank you. It's a particular pleasure. Sheila Gladstone, our speaker, is a principal attorney with the Austin law firm of Lloyd Gosselink, Rochelle, and Townsend, PC. Been practicing, speaking, and training on nothing but employment law for over 26 years. She graduated with high honors from University of Arizona College of Law, where she was editor of the Law Review. She is also a member of our own congregation and previously a board president, not a prime minister. And she is passionate on the topic of gender issues in the workplace, fascinated by how quickly American workplaces are changing and judges are jumping to make sure they're not on the wrong side of history. Frequent and popular speaker on the current workplace issues such as discrimination, harassment, disability and family leave, wage and hour law, and conducting internal investigations. She has been for several years running one of the very rare group of Texas attorneys selected as Texas super lawyers, and which recognizes outstanding professional achievement. And in preparing for this, she's told me that she has to check the morning headlines every day to see how she has to modify her presentation. Thank you. Sheila Gladstone.
Thank you, Gary. I got this. Thank you very much. We're going to talk today about one of my favorite topics to speak on lately. Now, remember, I'm going to talk a lot about what's going on in this country with marriage equality and same-sex marriage rights, but I'm an employment lawyer. I'm not a family lawyer. So that means that we're going to try to show how this is affecting employees in our workplaces in the United States, not only with the definition of spouse. Think about all the benefits that define the word spouse and how that definition is going to have to be changing in our workplaces, but also talk about how sexual orientation discrimination is changing in the law and in our workplaces. And gender identity also. So we're going to jump right in and talk about a little bit of history. Now, when I say history, we're talking about a year and a half's worth of history. So you don't have to be real old to remember this history. I always tell people that one of the things I love about employment law is that almost every law that I practice every day under was passed in my lifetime. That is, and the first one being 1964 Civil Rights Act, which we're actually going to be talking about when we're talking about gender identity issues. So other than the 1938 Fair Labor Standards Act, everything that I do happened in the last 50 years. Now, what has changed mostly is not only have we had brand new laws being passed in the 90s, the Family Medical Leave Act, the Americans with Disabilities Act were both passed in the 90s. That's pretty recent history. And then we've gotten laws passed as recently as 2009 that affect. But what's happening lately is all these laws are being reinterpreted, and the regulations have been updated very, very recently. So I want to give you a quick history of the Defense of Marriage Act. Everyone remember that? That's a dead soldier now, okay? So the Defense of Marriage Act was passed in 1996. 1996 is during the Clinton administration, so we have a Republican Congress and a Democratic president. And during this time, Clinton, as I'll show you, is passing laws protecting federal employees. He's doing executive orders, that's what he's allowed to do, that protect federal employees from sexual orientation, discrimination, and gender identity. Plus, we had all the dialogue going on in the military, right, about gays in the military. So all that's going on, and Congress decides to pass the Defense of Marriage Act, which says that for all federal purposes, federal benefits and things like that, marriage is to be defined as between one man and one woman. Not two men and one woman, but one man and one woman. So then, fast forward a few years to June 26, 2013, and we get the U.S. versus Windsor decision. And the Windsor decision, the Windsors, and I don't remember if both their last names were Windsor, but they were a all-female couple, two women. They were sort of the perfect poster child for this because they had been together for 40-some years as a devoted couple. They got married as soon as they were able to under New York law. So they were legally married under New York law. And what a lot of people don't realize is that this was an IRS tax case. So what happens is one of the Mrs. Windsors died, and the other inherited her estate, which was a large estate. And she gets a bill from the IRS for $363,000 in estate taxes, okay? Which you don't have to pay anything if you inherit from a spouse. That's one of the good things about marriage. There's a lot of penalties in the IRS code, but you don't inherit. You don't have to pay taxes on your inheritance. So there's an issue. Under Federal Defense of Marriage Act, the IRS was not allowed to treat her as married. Under New York state law, where she lived and operated under and planned for, she was married. So that's the case that goes up to the U.S. Supreme Court. And the U.S. Supreme Court decides a year and a half ago that the Defense of Marriage Act is unconstitutional. It violates the Equal Protection Clause of the Constitution. The Equal Protection Clause says that the state can't, or the government can't create distinctions unless there's a compelling government interest to do so. That's what the Equal Protection Act clause basically. There's obviously a lot of law in it, but it comes down to that. So there has to be a compelling government interest. And they compared this case to the Lovings or Virginia versus Lovings case from the 1960s. If you remember, if you remember that case, that was the case that said that interracial marriage laws were unconstitutional. So Virginia had criminalized interracial marriage. A couple named Lovings, which is kind of nice, were in jail because they got married. I think it was a black man and a white woman had gotten married, and they were in jail, criminally prosecuted. So that case was found to be, or the other way around, I think, actually. But that case was found to be unconstitutional under the Equal Protection Clause, that there was no rational basis for banning multiracial marriage. So that case is used when we're talking about same-sex marriage. All right? So that's federal. What about state? What about the fact that Texas currently has a non-struck-down clause currently that says that marriage in our Constitution of Texas, marriage is to be between one man and one woman, and no marriage may be legal in Texas if it's same-sex. All right? So we look back to the Supreme Court. Hey, what are you doing about this? Why wouldn't this be the same as federal? Well, they did some weird things in the Windsor decision. There's a very long decision. It's very interesting. Of course, it was a 5-4 decision. But it has a lot of language in it where it says, the federal government shouldn't be invalidating the state's rights to allow people to marry. If New York wants to let same-sex people be legally married, it's not the Fed's job to invalidate that for federal purposes. So they couch this decision in states' rights, which you can kind of see the problem with that also, because what about the state's rights to ban that marriage? On the other hand, throughout the decision, it talks about how there's no rational governmental basis for banning same-sex marriage, which is the same argument that would be used to invalidate a state law, right? Got the problem? Okay. Another case was also in front of the Supreme Court on the same day. That was the Hollingsworth versus Perry case. That was the exact question about California's Prop 8. Are same-sex bans under state law unconstitutional? Well, they didn't decide it. The U.S. Supreme Court passes on that case, decides we can't decide this, not for any legal, substantive reason, but because the right parties are not before us. If you were a same-sex couple that was not allowed to marry in the state you live in, and you would then be the ones to sue, and that's what happened in California. They sued, and they won in California. Okay? So they're not going to appeal, right? They won. California government is supposed to appeal to defend its statutes, to defend Prop 8. They don't want to. California government, the AG's office, the governor, they say, we don't want to defend that. We don't like that statute. We think the voters were wrong. And in fact, polls today show that the voters would have voted differently today. So we're not going to bother defending it, which there's a lot of controversy about whether they have the duty to defend that or not. But they said, we can't think of any basis to defend it, so we're not going to. So the winner's not going to appeal, the loser's not going to appeal. So who appeals? A public policy group, a family values type right-wing group, appeals on behalf of California state government. And the U.S. Supreme Court says you don't have standing. That's a legal term for you don't have the right to appeal because you weren't harmed by this law. And they're saying, yeah, we were harmed because our, society's going down the drain and we're part of society. And they're saying, no, you weren't really harmed. So you're not. So they dismissed that case. So that means that the issue of state law, federal constitutionality of state law, is still open. All right? So what's been happening? All right. So 2014 has been an exciting year. The end of 2013 and 2014 have been an exciting year for same-sex marriage rights, marriage equality. First of all, let's start off in November 2013. Same-sex marriage is legal in 17 states a year ago. Right? In December 2014, same-sex marriage is legal in all but 15 states. You can do the subtraction and the arithmetic, but there are a lot more states where it's legal, not only because state laws have changed, but because federal court decisions have invalidated certain state laws. All right? It is still illegal in Texas. Okay? There is a federal court decision in Texas that has invalidated Texas's same-sex ban, but that is on appeal to the Fifth Circuit Court of Appeals, and they haven't decided yet. They have been holding that case for almost a year, hoping that the Supreme Court will decide it for them and that they don't have to decide it, and that hasn't happened, and I'll talk about that in a minute. Okay. So, the 10th Circuit, which covers sort of Oklahoma, Nebraska, that area of the country, for the federal courts there. The 4th Circuit, that case came out of Virginia, and that covers a few other states in that area. And the 7th Circuit Court of Appeals, which is Illinois and Wisconsin, I think, and a few states around there. they have found that the same-sex marriage bans in the cases that came before them, and Virginia is kind of the first one. One of the first ones was Virginia, and that's kind of poetic justice because of the Virginia versus Lovings case. They found that the same-sex marriage bans were unconstitutional under the Federal Equal Protection Clause. Okay? Those cases, at least one or two of them, went up to the U.S. Supreme Court recently, about a month ago, and the U.S. Supreme Court said, we don't feel like ruling on it this year. So by denying the appeal, or denying cert, certiorari is the Latin term, saying that we don't have to rule on any case we don't want to, and we don't see any reason to do it for our 2015 docket, so we're talking about a long time, we're not going to rule on it. That effectively made same-sex marriage bans illegal in all of the states that the 10th, 4th, and 7th Circuits cover. So that actually validated or affirmed those decisions without actually specifically affirming them. All right. Then, soon after, like a week later or something, I don't remember how long, the 6th Circuit, which I think was waiting, just like the 5th Circuit, was waiting for the Supreme Court to act, and it didn't. Then the 6th Circuit Court of Appeals, which covers Ohio, Kentucky, Michigan, and Tennessee, or the bans, the same-sex marriage bans there, they come out, and they're the very first federal court in the country for the last year and a half to say, we think it's constitutional. We think that there's a compelling government interest, or enough of a reasonable government interest, to allow states to ban same-sex marriage. And it's a convoluted decision, but it talks about procreation, which, I mean, for those of us who are approaching menopause, I guess we can't get married anymore, because we can't procreate. But it talks about procreation as a compelling interest. It uses all the different arguments we've been hearing in the news, but it does. So now, what do we have? We have a split in the circuits. And the U.S. Supreme Court will take cases if they have to settle a dispute among the circuits. All right? So that means they'll probably, but they've already set their docket. I don't know if they all talk to each other or not to get this timing this way, but it's going to be another year, more than a year, before the Supreme Court takes this up. So right now we have a patchwork in this country, right? We've got same-sex marriage being legal in 35 states plus D.C., and we have same-sex marriage still illegal in all of the courts, all of the states in the 6th Circuit that have that law, plus all of the ones that haven't come up on appeal yet, which includes Texas, Louisiana, and Mississippi, which are in the 5th Circuit Court of Appeals. That court is in Louisiana, in New Orleans. Okay? Now, since that time, a little federal court in Mississippi has found that same-sex marriage bans are constitutional and are allowed. Okay? So that case is also going to get appealed up to the 5th Circuit. But right now, the cases that are before the 5th Circuit are Texas cases. All right? Those went up. So what we have are federal district courts nearly unanimous. We've got many, many of them, tens and tens of them, around the country, finding that same-sex marriage bans are unconstitutional and illegal. We now have one federal court in Mississippi finding that they are legal, and we now have the 6th Circuit Court of Appeals validating those laws in their states. Okay? That's where we are. Let's just show, if you can see this graphic, I'll tell you what the different numbers say. It's a little crisper on my screen here. The darker the orange, the more illegal same-sex marriage bans are. So same-sex marriage has been found to be legal. I'm sorry, let me start over again on that. Let's start with dark blue. Dark blue is where gay marriage is completely legal under state law and under some some federal cases. All right? And this was in November of 2013, so this is showing you a year ago. If you go to the darkest orange, we have constitutional bans on same-sex marriage, and that would be Texas would be included in that. So you can see that there's very little dark blue. The lighter blue color is where civil unions are legal, but were legal, but not same-sex marriage. And the gray is where domestic partnerships are legal. And then there's one state, there's like New Mexico, for example, you can't see on this map, but is actually very light gray, and that means they have no law in it whatsoever. But in New Mexico a while ago, the county clerk started marrying people, and there was a lot of controversy about that, and people courts involved to stop that, to put an injunction on that, which wasn't successful. So a lot of controversy going on. Let's compare this map. See all the dark blue? Okay, now we're going to put another map in front of you. Dark blue means that gay marriage is legal. All right? Medium blue means that civil unions are legal. And then the orangish colors mean that there are either legislative or constitutional bans or both on same-sex marriage. In Texas, we have both. It's kind of exciting. We have both a constitutional ban, which says that that marriage can only be between one man and one woman in Texas, and we have a legislative ban. It's in the family code that says that marriage has to be defined a certain way. Okay, that family code is interesting because there's a case that a state family court judge decided in Texas that's on appeal, and that case said that that was a couple that was legally married in another state, comes to Texas, and we forget about this side, the dark side of marriage equality, is divorce equality, right? So that couple comes to Texas, they have a child, they've got property, it's a community property seat here, they want to get a divorce. Does the family court judge have jurisdiction over that? Now, the partner who had more money doesn't want a family court judge in a community property state to have jurisdiction, right? The partner who doesn't have more money wants to have jurisdiction in a family court state. Well, that family court judge found that she had jurisdiction and ruled from a small family court in Austin that same-sex marriage was unconstitutional. Same-sex marriage bans in Texas were unconstitutional under both state and federal law, equal protection. Okay, so that decision's getting appealed through the family, through the state system. The case that's before the Fifth Circuit is more your traditional case. It's a San Antonio federal judge who, over a year ago, ruled that for two couples, a male-male couple and a female-female couple, ruled that their marriage, they could legally get married because the ban was unconstitutional. But don't get married yet, because this is being appealed, and we don't want to have all this confusion about marital status until the Fifth Circuit rules on it. Well, the Fifth Circuit has been holding that case for a long time. All right? Okay, here's on the current marriage map, we have marriage bans that remain only in the Deep South and certain Midwestern states right now. But there has been quite a few cases coming out of the Deep South where federal courts have found that the bans are unconstitutional, except for this is the case I was talking about, Mississippi federal judge, and I did get that wrong a little bit earlier, the Mississippi federal judge actually struck down that state's prohibition, but there was another federal judge that found the opposite. Okay, so the score, it was the Louisiana federal judge that upheld it. So the score in our Fifth Circuit, remember Texas, Louisiana, Mississippi? We have Texas and Mississippi that still ban, the judges have found that the ban is unconstitutional, and it was the Louisiana federal judge who said that the Louisiana ban was constitutional. All right? Fifth Circuit decision, oral arguments are now finally set. The briefs had been sent quite a time ago. Oral arguments are set in the Fifth Circuit in January of 2015, and we should get a decision sometime after that. Again, I think they were holding off to see if what the U.S. Supreme Court would do, and also knew that the Sixth Circuit Court of Appeals was going to be deciding this. And now it probably didn't want to be the first one. If the bad news is that going in that direction, didn't want to be the first one to uphold the ban. So we'll see what happens in the Fifth Circuit, and then that will be yet another one that will be headed to the U.S. Supreme Court. So our current but soon-to-be former Attorney General has filed the briefs in the Fifth Circuit defending the ban in Texas, and we'll see what happens then. So the name of that case is DeLeon versus Perry, and that was decided in February 26th. Now, just recently, I read in the paper, just this last few days, that the couples who were found to be allowed to be married in that case have petitioned the same federal judge and said, look, it's been a year. Can we please get married yet since you decided that? And he just issued an opinion that said, yeah, I still think this is horrible. I still think it's terribly unconstitutional what's being done to you. I still think you have the right to get married, but let's wait a little longer because we don't want to have people marrying and then having to not be married again under the law. Now, those couples could go to other states and marry if they're worried about the tax year ending or something. They could do that, but I think that they really want to do it in Texas. Okay. Public opinion polls are certainly changing. Let's just look at the dates. 2001, public opinion of Americans supporting same-sex marriage was 35%. 2014 is 52%. A Gallup poll asked, should marriages between homosexuals be recognized by the law as valid within the same rights as traditional marriage? 1996, 27% support. 04 was 42% support, and 14 was 55% support. So we're seeing a rise, but that's certainly barely a majority. So you have to remember that although sometimes the people we know agree with us, is a pretty large, almost half of the population that doesn't. I just gave a talk. It was a 3-city tour talk to the Texas Society of CPAs. I was in Houston, San Antonio, and Austin, and Arlington, and large, huge groups. This is their yearly conference, and in all 3 cities, somebody felt comfortable enough to stand up to ask the question, as a CPA, if a couple comes to me and wants them to do their joint tax return as a married couple, if they're a same-sex couple, may I send them away? Am I allowed to deny them service? All 3 cities, I got the same question. So and then I don't know if you heard about this wedding cake baker in Oregon who didn't want to put 2 men on the top of her cake. She thought that was weird. She was actually prosecuted under state law because their state law makes it a civil rights violation, and it would be just like turning away people based on race. And there was a similar case in New Mexico, I think, with a photographer, was it? But anyway, in Texas, I have to tell them, so far in Texas, it's still legal. It's not a civil rights, it's not a clear-cut civil rights violation to turn away this couple. However, and he said, well, what if I just don't know how to do it? I don't have experience. I said, the federal law just said it's exactly the same as a heterosexual couple. It shouldn't be any trick to try to figure out how to do a same-sex couple tax return. All right. So that's still out there. That's still some of the feelings out there. I'll talk about employment law a little bit and also tax law. After the June 2013 opinion, the IRS announced that from now on, if you are legally married anywhere, you will be a spouse for tax purposes. Okay? So soon after the Windsor decision, now the IRS has announced this. The residence is irrelevant. That means that if you're legally married in New York or in Canada and you come to Texas and you file your joint tax returns, under federal law, you'll still be a spouse. Now, I deal with the Department of Labor. That's my job as an employment lawyer. Federal Department of Labor changed their position. Now, does everyone know what the Family and Medical Leave Act is? Family and Medical Leave Act gives employers that have enough employees, gives the employees the right to take time off to care for a seriously ill parent, child, or spouse. Okay? So, in 2013, they said, we're not going to change our definition of spouse quite yet. We're only going to require employers to let you off of work to care for a spouse as defined under the state in which you live. So even if you get married legally in New York, you don't get to take time off from a Texas employer if you live in Texas. It got real confusing, though, in some of these tri-state areas where people lived in a different state than they worked, and the employer had people from 3 or 4 different Connecticut and New York and all that. So, in 2014, August, a year later, the Department of Labor said we want to update this rule and make it consistent with the IRS rule. So they call it now, you'll hear this term, state of celebration. So the state of celebration is what we're going to look at. Or if it's outside of the states, if you get married in another country, it needs to be a marriage that would be legal in at least one of our states. What are they worried about? Why did they do that kind of language? What are they worried about? Yeah, they're worried about you got married in some country that recognizes the right to marry animals, or recognizes polygamy, or recognizes, 10-year-old girls being married or something. So it has to be legal in this country, but not in the state where you reside. Now, that hasn't officially changed yet, but it's likely the rulemaking is done, and it's very likely, it's almost for certain that it will change very soon. So one of my jobs is reviewing employers' policies and definitions and procedures. We've been changing this definition in the policies with the understanding that it's likely going to change. But I've got some public sector employers that are saying, but the Texas Constitution tells us we're not allowed to. It's illegal for us to recognize same-sex marriage for purpose of benefits. What do we do? Well, I'm telling them, you could get sued under federal law if you violate people's civil rights, or you could less likely get sued under state law for allowing that. So it's probably safer to err on the side of recognizing the marriages for benefit purposes. But that's just my opinion, and they're getting other opinions also. And you remember, some of these jurisdictions are in very conservative areas where their board members, for example, of a public utility, really want to make sure that they have to do this before they'll do it. So they want opinion letters from me saying you have to recognize same-sex marriage, and I can't give it that definite yet. I will soon, but not yet. ERISA is the law that covers health insurance benefits, retirement plans, 401k plans. That the DOL has also said that if you're legally married anyway, that you're a spouse for benefits purposes. This is now allowing same-sex couples, even in Texas, to put their spouses on their health insurance, which is a big benefit. And also, back in 2013, the DOL announced that if you do need to err on the side of providing families with the most maximum protection that you can. So that's sort of the state of the law on marriage in the employment arena. I want to talk now about sexual orientation and gender identity discrimination. Now, in this map, which has different shades of green in it, the very darkest, blackest green shows where there is a state law on non-discrimination of sexual orientation and gender identity. That is, about 18 states have state laws protecting people based on discrimination. By the way, you can now get married in more states. You can get married in states that can still fire you for being gay. So it's still adjusting. The lighter green has sexual orientation non-discrimination law only. There's no protection for gender identity. And then the rest of the states just have no state-level protection. So you'll see Texas in there. But we're also seeing a lot of jurisdictional local jurisdiction. So, for example, the city of Austin prohibits sexual orientation and gender identity discrimination. They don't have a lot of teeth in that law as far as enforcement. They can enforce it for their own employees. They can enforce it for people doing business with the city of Austin. They can make people, they can require that. They can do investigations and find that a city of Austin business is violating it, but they can't, there's not really anything you can sue under that law. But you'll see that the darkest color shows that 100% of the population is protected because there's state law. And then the darker green, like Utah, protects about 50% of the local ordinance protect about 50% of the people. The striped ones protect about 25 to 40% of the people. And the white states have no local ordinance whatsoever protecting in employment law on gender identity or sexual orientation. However, the large workplaces themselves are putting those policies in. They're saying regardless of the law, we're going to prohibit it in our workplace. So among the Fortune 500 companies as of last spring, 98% prohibit sexual orientation discrimination in their policies. And part of that's because they cover a lot of states and they don't want to have different policies for different states. And 84% protect gender identity discrimination. For the top 50 federal contractors, 86% are protecting sexual orientation discrimination, and 61% are protecting gender identity. Okay, but I want to talk about the fact that the federal EEOC, the Equal Employment Opportunity Commission, which governs Title VII. Remember, I talked about at the beginning. The Civil Rights Act of 1964 protects discrimination based on race, religion, sex, and national origin. And so the other protected classes came in later, but that was the 1964. So under gender discrimination, the EEOC's position is that if you act in a way that is not stereotypical of your gender, then discrimination for that reason violates Title VII. See what we're saying? So if you, first of all, they tried to pass, it's been trying to pass ENDO, which is the Employment Non-Discrimination Act, but it's gender identity and sexual orientation. They've tried to pass it and add it to Title VII type laws, and they haven't been able to over and over again. Passed the Senate in 2013. The House won't vote on it. The Speaker of the House has said repeatedly that it will not show up on his floor. So ENDA didn't get passed. It was introduced. They tried to introduce it as an amendment to legislation to fund the military, and it still didn't pass, even as a rider on the military spending. In 95 and 98, President Clinton had issued executive orders to protect federal employees and federal service, but specifically accepted the NSA, the CIA, and the FBI from that. Okay, but the EEOC decided in their own decision against another federal agency in 2012 that gender identity discrimination was illegal sexual discrimination under Title VII. And they went after the ATF, which, by the way, is now called the ATFE. It's all the fun stuff: alcohol, tobacco, firearms, and explosives. They went after another federal agency. That agency had hired an agent for a position that wasn't going to open for quite some time. Someone was going to retire. So during that, I think it was a 6-month period, they did they were vetting them and, said you're going to be hired contingent on the background check, but everything was going fine. The agent used that time to change his gender to female. So now the agent is she. And called the office she was going to be working in a few weeks before she was to start work and say, hey, by the way, heads up, I'm now presenting as a woman. And they said, oh, darn it, we just lost our budget for that position. Sorry, you're no longer being hired. So there really wasn't much question that they had decided not to hire the agent because he became a she. All right? And so the EEOC went in and said, we don't need endo. We don't need a new statute because we have Title VII. And gender stereotyping has been illegal since the 90s. There was a decision where a woman didn't make partner at Price Waterhouse on Wall Street, and she was told that next year, if you want to make partner, here's some suggestions. Slap on some makeup, act a little more feminine, try not to be so aggressive. And she was able to show that she was the first stockbroker ever to be told to be less aggressive, and that men were not being told that. So she was able to win in the 90s under that gender stereotyping is a type of gender discrimination. They said it's the same thing with whether you act effeminately, whether you dress as a woman, however that is, it's still gender stereotyping. It's illegal. And we've had a few courts agree, but where it's coming up in our workplaces is, for example, our dress codes. I still review dress codes that have the male column and the female column of how you're allowed to dress. And now we're starting to make those dress codes gender neutral. If someone wants to dress as a woman, they still have to follow the dress code, but they can still dress as a woman. And there has to be some compelling interest to have it different for men and women. For example, if you have to show up in court, men need to wear a tie. Women don't need to wear a tie. But if you're presenting as a woman, then you don't need to wear a tie. Okay. The big issue has been the bathrooms. So we have someone who's biologically male, who's presenting as a woman. What restroom does she use? And we get a bunch of women in the workplace saying, "Ew, we knew this person when she was a man, and now got this 6', 2' person in our bathroom, and it makes us nervous." Well, the EEOC has gotten up at a podium over and over and said, "We don't care about the bathroom issue. If someone is presenting as a woman, that person can use the women's restroom, and the women who are uncomfortable with that need to get some sensitivity training." That's basically what they're saying. So the bathroom issue seems to be off the table. It doesn't mean someone gets to act inappropriately in the bathroom and parade around naked. They still have to have some decorum, just like anyone else would. And what I always tell men, it seems like men get more upset about a biological male using the women's restroom than women are. And I have to explain to them that you may not have ever been in a women's restroom, but we actually have stalls on the doors. So, doors on the stalls, so it's not a big problem. But there have been cases. So right now, if you have local legislation or state legislation, you can sue under that. But if you feel you've been, if you're gay, let's say a gay man is where most of these cases are, a gay man in the workplace is being discriminated against, not because he's dressing as a woman, but because he's gay. And he's being harassed in the workplace or terminated because of that. It's still a little bit unclear what kind of legal case he's got. It's weird because if he acts effeminately, he has a better case than if he doesn't act effeminately because of the gender stereotyping issue. So we have a case from 2009 that a lot of cases have followed, where we've got a male gay plaintiff who has self-described himself over and over as a very effeminate male. And he does a lot of what we think of as the stereotypes of an effeminate male. And he's been accused in that workplace of pushing boundaries, making sure people, it's kind of in your face is what he was described as. And he did answer in his deposition, "Yes, I agree, I may have pushed the buttons on my machine with pizzazz." So he's definitely being very, trying to show that he's effeminate. And he's in a manufacturing environment, and they manufacture and process business forms. And so he starts claiming that he's being harassed. And it starts out, he's sort of doing it himself. He's teasing himself. Other people are teasing him. And then it gets kind of nastier and nastier is his allegation. They stop calling him by his name. They call him Princess. They call him Rosebud. He came to his machine, and there was a pink tiara with rhinestones waiting for him on there. And then it started to get intimidating. He was afraid to use the restroom. There was graffiti. And it started getting meaner and scarier for him. And they all sat around, and they swished around when they walked, and they imitated the way he sat and all that. And it got to be uncomfortable for him. and threatening, he said. The court found in his favor, they found that this was traditional gender discrimination, that he was harassed because he failed to comply with traditional male stereotypes. Now the question remains is if he did comply with traditional male stereotypes but they found out that he was gay, would he have a cause of action? I would argue yes, because it's a traditional male stereotype that you're interested in women and not men. So you could argue that, but we haven't seen that case in a jurisdiction that doesn't have other protection. But again, those seem to be changing pretty quickly. So that's what I have on the state of gender discrimination, gender identity. I'll open it up to questions right now. If you have any, thank you.
Thank you, Sheila. Well, I know this is going to inspire some good questions. Dr. Phil.
It's my understanding that the federal law, which would include Social Security, is okay for same-sex couples. Why? I found an article in the Statesman.
I'm not going to be up to date.
This is a month ago, October 23rd, and one of the people that comes to this church is having to sue the SSI because she's being discriminated against being in a same-sex couple.
Okay, so I don't know that particular issue, but it should be under the IRS regulations, under the DOL regulations. They should be treated the same if they were legally married in another jurisdiction. The question may be, the timing of that. They may have declared themselves legally married prior to this case, and that it may be that it only goes back to a certain time. There may be questions about, is it a domestic partnership or is it an actual legal marriage in that state? But my understanding of the law is that shouldn't be happening. My understanding is if they have a legal marriage certificate in a state that recognizes marriage, they should be treated exactly as an opposite-sex spouse that was married on that day. The other thing is things move so slowly in the Social Security Administration. That case could have been filed 3 years ago, and it's still being hung up in bureaucracy, too. So,
do we have any more questions?
Yeah, over here.
Yes. Could you say your name, please?
Carl Willman. So look into your crystal ball and tell me how potential changes on the Supreme Court, some potential retiring justices, could impact movement at a federal level.
Yeah, so almost every decision that's controversial these days is a 5-4 decision. Justice Ginsburg is always usually in the minority of those decisions, although there's some swing votes. So we are seeing some more progressive decisions. But if Justice Ginsburg retires, and she's really trying to hang on, but I don't think that she's going to be able to work that much longer. Obama should still have time to fill her spot, but the Congress has been holding up these nominations, at least in the lower federal courts. Here in Austin, we have a brand new, beautiful federal courthouse with eerily empty courtrooms because we can't get any judges confirmed. So, but I think that it looks like the judges who are leaving soon are going to be replaced by judges that have the same views if they're replaced by Obama. And so I'm not seeing a lot of, in this administration, I'm not seeing that the makeup is going to change the law. However, remember, it was this court that decided the Windsor decision that found that the federal law was unconstitutional. So I'm not sure if they're going to really be able to come up with different reasons to uphold the state bans. So we'll see. If the next president is also a Democrat, which we don't know, then I think we're going to start seeing some real changes in the Supreme Court, but not in the next 2 years probably.
We have a question here. Would you stand and say your name, please?
Hi, I'm Bayla Rubin. I'm a nurse practitioner, a women's health nurse practitioner, and I'm curious about the movement throughout the country. It's very tiny, but it is there. in recognizing that genetically, endocrinologically, that there is a definite mixed gender, not pure female or male. What on earth is the country or states doing with that? It's more and more of a movement to not do plastic surgery to make the outward appearance be one or the other gender, but to let that human choose, to be mixed gender or whatever. What on earth are we doing with that?
I don't know.
I think that is really an important question, even if it's a minority.
Yeah, that is an issue that people don't seem to be ready to deal with quite yet. My daughter Kate is here. We were arguing last night because I was trying to correct her essay grammar where she was using the word they for a singular noun, and I said you need to say he or she, and she said not everyone identifies as a he or a she, and it kind of stopped me cold. So I think that what we're seeing is a movement among the very young, among the 15 to 25-year-olds, to start looking at ambiguous gender, at not being in any specific gender categories, and it's been very interesting. People are struggling with pronouns, but so far we haven't seen those types of major changes in that area yet. As far as we're still a I don't want to say bisexual, a dual sexual society, and so we haven't seen. Now, I also have a group of clients that are in criminal justice that run jails and run detention centers, and they are really struggling with this issue of people who are biologically male choosing to present as female and what prison population to put them in. And they're talking about, the dangers to the person, regardless of which one they put them in. And in some of the larger jurisdictions, like in California, they're even talking about possibly, a third detention center, a third prison. So it's very confusing to people right now, and it looks like things are changing. Also in the hospital area, what we're seeing is, for example, the definition of family member who can visit somebody. That same-sex spouses and even domestic partners are now being allowed into the hospital rooms when they weren't just a couple of years ago.
Mm-hmm. Sheila, I have a question, and this ventures more into maybe non-legal areas, but let's say an employer has been told that they can't engage in this kind of discrimination. Then do you see that perhaps the person is badly treated in other ways, but they may not be protected under the law? What do you see?
Well, the law, one thing that's, if they're found to be protected, for example, under Title VII sex discrimination, then they're also automatically protected against harassment based on that and also retaliation for making a good faith complaint about it. So the fact that that case that I showed you, that Prowell case, he was not terminated, but he was harassed in the workplace, and that was the case. So we are seeing, just like in any other protected class, when somebody makes a claim about race discrimination, for a promotion, there's always an allegation after that they're being treated different because people are angry at them for having made that allegation. So we are seeing that if it truly is, that's why it's so important to activists to get it in under Title VII, because then that pulls in the other protections. Thanks.
Any more questions? Dr. Phil Richardson.
Sort of a legal quandary that I see. The Texas legislature is probably very hesitant to ever change the Constitution. It's my understanding that sodomy laws are still in the Constitution.
But they've been found to be unconstitutional, right. So we just ignore them, is basically.
Well, but do they?
Right.
Because it's my understanding that if a sheriff in a very conservative area decides to lock me up, he can. It won't last, but I think the same thing might happen with marriage.
Right.
What do you think?
Well, once the U.S. Supreme Court finds that, or the Fifth Circuit, if it's not reviewed, finds that a Texas provision of our Constitution is unconstitutional federally, the primacy clause says that federal law is governing. They don't have to take it out of there, but it's completely invalidated. And if the sheriff were to put you in jail under the sodomy law or under a same-sex, or not allow you certain privileges as a spouse, then that sheriff could be sued individually for civil rights violations under what's called Section 1983, which allows you to sue individual public officers for violating clearly established constitutional rights. And once the Supreme Court rules on something, it becomes a clearly established right. So not only would the conviction for sodomy be overturned as unconstitutional, but he would be putting not only his county or his agency at liability risk, but also personally, because he wouldn't have immunity from that kind of lawsuit. So that's the way it usually works. Hopefully, when they do these regular reviews of the Constitution to fix little things, they'll also fix some of these big things.
Sheila, we want to thank you for this outstanding, cutting-edge presentation, and we're all so much better informed, and there are very few people who could give us this kind of update. You're a superb attorney. Let's give her a big hand.
Thank you.